5 seconds to go. Start. It is now well settled that the crucial point of time at which unsoundness of mind should be established is the time when the crime is actually committed, and the burden of proving this lies on the accused. Stop. In Thakkar vs. State of Gujarat 1964 7 SCR 361 it was laid down that there is a rebuttable presumption that the accused was not insane, when he committed the crime, in the sense laid down by section 84 of the penal code, the accused may rebut it by placing before the court all the relevant evidence, oral, documentary or circumstantial, but the burden of proof upon him is no higher than that which rests upon a party to civil proceedings. Stop para. If from the materials placed on record, a reasonable doubt is created in the mind of the court with regard to the mental condition of the accused at the time of occurrence, he shall be entitled to the benefit of the reasonable doubt and consequent acquittal, as observed in Vijay Singh vs. State of UP 1993 SCC 190. Stop para. Chapter 25th of the Code of Criminal Procedure 1973, hereinafter CRPC, though procedural in nature, also becomes substantive when it deals with an accused person of unsound mind. Stop. A well-laid procedure is contemplated under sections 328 to 339 of CRPC. Stop. There is not even a need for an application under section 329 of CRPC in finding out as to whether an accused would be sound enough to stand a trial, rather it is the mandatory duty of the court. Stop. Under section 330, the court can even go to the extent of discharging such a person if his inability to stand trial continues with a rigid chance of improvement. Stop. As per section 334 of CRPC, the judgment of the court shall include a specific finding that the act was committed due to unsoundness of mind, though it was actually done. Stop. The reason is simple, as there cannot be an acquittal on the ground of unsoundness of mind unless the act is actually done. Stop. Para. The whole idea under the provisions discussed is to facilitate a person of unsound mind to stand trial, not only because of his reasoning capacity, but also to treat him as the one who is having a disability. Stop. The role of the court is to find the remedial measures and do complete justice. Stop. Para. Having noted the scope and ambit of chapter 25th of CRPC, including the provisions incorporated by way of amendments in the year 2009, one has to take into account the fact that the court has a larger role to play while considering the case under section 84 of the IPC. Stop. If a friendly approach is required to be followed during the trial, when adequate powers have been conferred upon the court to even discharge an accused on the ground of unsound mind, the same reasoning will have to be applied with much force when it comes to section 84 of the IPC. Stop. Para. We find adequate materials on the assessment and evaluation of legal and medical insanity, which are totally different from each other. Stop. We shall furnish the following relevant material on medical jurisprudence. Stop.